There are 1 million, yes, 1 million people in the U.S. placed on a sexual offense registry, and the restrictions imposed don't stop just with the offender. Like biblical days of old, they are passed on or visited upon their children and their children's children. It's very Old Testament. Here's one story. Danielle, age 34, and her husband Will wanted to have a child, and yet, like many couples, they were unable to give birth for medical reasons. So they looked into adoption and foster care as possible alternatives. However, a problem turned up when the foster care agency underwent a thorough examination of Danielle and Will's background. Danielle's father was convicted of a sexual offense 25 years ago and placed on a sexual offense registry. For this reason, their application was denied. Danielle and Will appealed the decision, explaining that her father's offense did not involve sexual contact and that he was no danger to children, and that it made no sense to treat sexual offenders with a one-size-fits-all approach. She offered to show them her father's psychological reports as proof. The agency relented on one condition: that Danielle and Will break off all contact with her father. They were asked to sign a form which held her legally liable if they violated this condition. The agency was very specific about this and offered this example. If Danielle or Will and the foster child were in Walmart and they happened to see her father shopping in the same Walmart, they are required to call the police to have her father removed from Walmart. They are not allowed to approach her father and ask him to leave because such close proximity would endanger the child. They must call the police to have her father removed from the premises. If they fail to do that, they will be held legally liable. This is wrong on two levels. First, it's blatant monsterization. To monsterize someone is to vilify them to such a degree that they become an unredeemable monster, something you can't reason with, something you run away from. So when a law such as Nebraska Revised Statute 43.2933 presumes that a child is at significant risk from someone required to register as a sex offender, and that such a person shall not have supervised or unsupervised access to children, that is blatant monsterization. And second, the presumption is wrong on its merits. Many states and even the U.S. Supreme Court have assumed that recidivism rates for sexual offenses are, quote, frightening and high, estimated to be as high as 80%. But this off-quote statistic comes from a 1986 magazine article that did not provide a source, and its author, when asked by legal scholars, admitted that the number was a guess. That guess was way, way off, as more than a few research studies have shown. A 2003 research study by the U.S. Bureau of Justice followed nearly 10,000 sexual offenders and found that only 5% of them were rearrested for another sexual offense. 15 years later, new treatment techniques are lowering this rate even further. Laws that assume otherwise make little sense, and as this story shows, can not only adversely impact people required to register, but also their extended families. Are you surprised or angry that this is how the United States, who claims to stand for second chances, treats its citizens who are simply trying to move on and become productive members of society? To learn more about laws in a specific state, visit NARSOL's State Law Wiki at the link below. To get involved, visit narsol.org and join, donate, or volunteer. Visit lives.narsol.org to learn more about this video project and how to participate. We make every effort to assure our stories and law references are accurate. However, they should not be considered as legal advice. Laws constantly change. Please consult an attorney to confirm how they apply in your situation. To hear more stories about the registry, click the like and subscribe buttons.